At present, he is working as professor in the Department of Law, Aligarh Muslim University, Aligarh. Sir is a keen researcher and session teacher having special knowledge in jurisprudence, labor law, constitutional law, human rights, and general studies. Having a teaching experience of more than 20 years, he is totally committed to research, writing, and administrative works. He has published three books, namely Labor Welfare and Dr. Ambedkar's Vision, Human Rights, Health and Related Issues, Human Rights Issues and Challenges, and working on other books on PIL and administration of wage system. He has more than 40 research papers, articles in leading journals, and periodicals are in his credit. There are 21 research scholars, including those whose PhD has been awarded and those pursuing research under the supervision. He has supervised more than 70 dissertations in the discipline of law. He is member peer team and assessor National Assessment and Accreditation Council NAC Bangalore. Sir has received three awards, namely AMP's National Award for Excellence in Education in 2021 for exemplary work in the field of education, Sikshawit Educationist Award, and Uttam Award in the field of legal education and legal awareness. He is an editor of Aligarh Law Journal since 2014-15 session. He has organized more than 25 seminars, conferences, moot court, and other national and international events. He has delivered more than 50 lectures as a resource person in different institutions of national and international repute. He has participated and presented research papers in more than 60 seminars, conference, workshop, etc. He has been engaged with National Commission for Women, New Delhi, as an expert for scrutiny of proposal received from conducting seminar, research studies, and evaluation of studies research already carried out. Sir has successfully completed University Grant Commission sponsored project and also played the role of observer in examinations conducted by various agencies like NTA, CBSE, and various universities. For almost 6 years, he had successfully discharged his duties as coordinator of Indira Gandhi National Open University as a coordinator, observer, and in charge. With the unending achievements that Sir has, I would like to invite Sir to deliver his lecture. Welcome, Sir.
Hello,
Yes, Sir. Please start your
are you
lecture.
hearing me?
Yes, Sir. Sir, you are
Okay, no
audible,
problem.
Sir.
Are you hearing me?
Yes, Sir. Yes, Sir. You are audible, Sir.
I think there's a net problem because in the legal and adjacent area of Delhi,
Yes.
there's a weather of rain and somehow the fog been blowing from last 1 or 2 hours. We are
Yes, Sir.
too late just because of you can say weather problem or the unavoidable circumstances. Sorry for the participants, the regret because he could not just join in time. But
Yes.
in offline mode, online mode, there is a difference. The difference is like this one. And every issue has a merit and demerit. So I'm just too far from Lucknow, but I'm here before you. It's a merit. And what the net problem has, or the instrument, or like laptop or the mobile, some problem, that's a demerit. No problem. Very good afternoon to all of you, media organizers and participants. Dr. Naseem Ahmed Saad Jafri, head of the Department of Law, and particularly Dr. Mirza Junaid Beg, he was also the student of this faculty, and Dr. Sadaf Khan, and somehow Mr. Khan, who was just calling me. I don't know what the full name of this guy. I was very just he's very keen to join for the last 45 minutes. Anyway, so come to the point. First of all, just I have just it's my foremost duty to give a very big thank to just newly uh, faculty in comparison, comparatively, so the new faculty and somehow young people were just I am watching it. And it's a very good luck to all of you. And inshallah, I hope that under your leadership and under your uh, supervision, the Faculty of Law of Interior University Lucknow will reach on its height. I hope so, and it will do it. What I am seeing is enthusiasm that you have towards your faculty or towards your institution. That's a good one. Anyway, what you have just assigned me a topic on, I think it's a very good, and now it's a, very debatable, the hot, you can say, debate of the present time, that gender neutral laws and somehow the sustainable development. And really, you deserve for the appreciation as to select a very good topic and very mind-boggling issues nowadays that you have chosen. So the organizing committee deserves for the appreciation. Particularly, I began because you know that Mirza Junaid Beg was very active also in the faculty of law in Modigar at that time when he was pursuing his PhD. So, I'm very happy that you have had such a good program. And last night, Mr. Junaid Beg has shared with me that so many resource persons, the reputed legal tribunals have contributed. I am a very bad professor, and somehow, but I know about it, the particularly of the issue that I will share with you. Now, come to the point that because we have just lost a lot of time last 1 year, one hour. Anyway, you know that the term gender neutral means that that is independent of gender. What the term gender neutral means, and to my mind, it's independent of gender. That's equally applicable to both male and female. Equally applicable to both male and female. And the man and women along the ages have been legally differentiated on various grounds. And the Constitution of India, when you go through this, that provides every person is equal before the law and gives every individual the right to live with human dignity. And in addition to it, every citizen of the nation gets the right not to be discriminated on the basis of religion, race, caste, sex, or place of birth. Likewise, it has been heard for the 111 more than 100 criminal laws in India to have a gender neutral approach. And the laws in India relating to rape under Section 375, 77, 76, 76 of the IPC suggest only a man can be convicted of rape. The victim is always a woman. Even laws concerning issues such as sexual harassment, stalking, voyeurism are also gender specific in India. And it is preconceived notion that the women always fall under the canopy of victim part and men always fall under the perpetrator part. But the scenario is that man too become victims of sexual offenses as well as false accusations. Furthermore, you can just go through the section 497 of the IPC. Are you hearing me? Everything is clear, the video and the voice? Dr. Sadaf or Dr.
Yes, sir,
Khan?
you are audible, sir. Yes, sir, you
Okay.
are audible, sir. And we are
So,
live on
further,
YouTube, sir.
okay. Under section 497 of the Indian Penal Code, you know that it said that all the men are accountable for adultery. And now it has been just been a change after the 100 years, you can say. If a married woman is found to have an affair or caught in such act of adultery, she is not guilty of such offense. Even the Justice Verma Committee had recommended gender neutral rape and sexual assault laws. However, such recommendations were kept in cold storage by the government. And due to pressure of activists, the Criminal Amendment Act 2013 was passed without the much needed gender neutral reforms. That was a problem. Now come to the Article 14. Uh, what the Constitution specifically says about the uh, uh, equality. Article 14 of the Indian Constitution said equality before law, that each and every citizen of this country is equal and subject to no discrimination on any grounds of color, caste, creed, sex, and so on. Though our constitution is very clear on no discrimination based on gender, but there are certain laws where there discrimination exists. To achieve the goals stated in the Indian Constitution, the time is ripe for proper implementation of gender neutral laws in India. Needless to say that justice is a must for all, and to achieve justice for each and every one of the society, either it's a male or female, doesn't matter. The law must be absolutely gender neutral. But always remember that our Article 14 says there are two clauses. First one, no, and equality before the law and equal protection of the law. So everyone is equal in the eye of law, but the class is different. It will not be treated if you are just giving a special privilege to a class which is permissible class. So you know that it will not be amount to just say that it's discrimination. So what does gender neutral laws mean? The word neutral means to be impartial or unbiased. You know, and this word, when combined with the word gender, means that each and every citizen, be it male or female or transgender. Now the third approach is a very much competitive, very new. You can say it's not a new, but approach is the term is not new. Male, female, or the transgender. Third one is subject to equal and fair treatment. No one is superior or inferior in the eyes of the law. And gender neutrality means if a person of any gender commits an act of crime, then the person is accountable to be punished as established in the law without considering the gender of the involved person. For example, under the Pox Act, a child has been defined as any person below the age of 18 years without specifying any gender. The word any denotes equality to all genders. The real question is, does India follow the concept of gender neutral laws? India has a population of approximately 1.3 billion people, more than 1.3 billion people living in the country. So the people of all sexes, a male, a female, or transgender, live in the country. So this is a country of all people, all types. There are three types of genders, you know, male, female, and another is transgender. Still, the concept of gender neutral criminal laws in India is hard to find. There are many laws that favor female when compared with male, and some laws which favor male over female, where the rights of the transgender are overlooked or silent at times. You know very well about it. And my viewers, you know that we need to change our mentality, our mindset from gender equality to gender neutrality. It's a challenge for the nation, challenge for the system, challenge for the state to change our mindset from gender equality to gender neutrality. Master, I think it's the right time to think about it. And there is no use of equality if the laws in the country are not neutral and favor one sex. So no one is inferior or superior, each and everyone shall be subject to the treatment. That's right and necessary. And it is very unfair that one sex is favored by law and the other sex is guilty, is not given equal punishment. So that the government, the people, the NGOs need to work hand in hand to bring about the desired change to give effect to gender neutral laws in India. And you know that the gender cannot be taken as a sole criterion to suggest that male is the offender and the female is the victim. You can just quote an example about the rape laws. Rape has been seen as a female-centric crime all across the world. Not just you can say in India only. It's a world phenomenon. And like sorry, You know that the rape was defined as a 375 in penal code. I think that it's based on the belief that only women can be victim and only man can be perpetrator. In addition, provisions related to sexual harassment, violence, and stalking and sexual assault are also gender specific. Defining only man can be a perpetrator and only women can be victim. You know that meanwhile, the state has largely ignored the problem of being transgender, sexual victimization, and the institutional settings such as prison, juvenile detention centers, etc. Therefore, making that nature dynamics and consequences of male and transgender victimization continue to advance. The concept of male and transgender sexual victimization has been largely neglected in modern academic and legal debates and is frequently ridiculed and mocked. While men are conceptualized as the sexual aggressors, however, there has been increasing research examining the experience of male victims with the criminal justice system, which has debunked many societal myths about adult male sexual victimization and highlighted the magnitude to which these apprehensions about male and transgender rape influence the attitude of the criminal justice professional and the general public. To put it in another way, they laws that exclusively recognize man as a potential perpetrator are based on essentialized concept of male aggressiveness and female subservience. And it's very difficult to admit that the fact that women can also be sexual abusers and they are still seen as subservient, weak, and fragile. To change the present scenario, the government, you know, that most needs to understand the condition required to gender neutral laws being established in India. The belief in the idea of being impartial and unbiased in every decision the government takes must be reviewed. The concept of the, gender neutral criminal laws in India shall only take place because of the collective effort and the pressure of the media or the intellectuals, pressure of the academia and the common people, non-government organization, other institutions which keep check on it, right? Somehow, if it's their views, you know that if you go through that the international instrumentalities that you'll find that the goal of promoting gender equality or equality between women and men has been on the agenda of the international community since the founding of the United Nations. And it is well established in the UN Charter. And world leaders assembled at the 2005 World Summit, the very popular, the famous summit at the United Nations in New York, affirmed that progress of women is progress for all. That was the slogan. And this, I think, is a very good slogan, and that every nation or every state has to follow it. Progress for women is progress for all, and without progress for women, because for women is a definitely is a very biggest section, and it's a marginalized class. You know, UN recognized gender inequality as one of the predominant problems in today's world in 2010. And the United Nations created the UN Women Division to address this issue of gender inequality. And you know that the UN Women is dedicated for empowerment of women and gender inequality. All around the world, women are underrepresented and denied access to basic facilities like education and different amenities in society. In matters of the politics and the finance also, they are not allowed to raise their voice, nor have the chance to stand. You know. And before the creation of United Nations Women by General Assembly, the work of the UN, you know that gender equality and women empowerment divided into different parts. And that was thoroughly discussed the issue. But the problem is that whether that's we are following that this issue has to be discussed not only by the United Nations but by the concerned states, because no doubt that international some other people say that international law is weak law, as a vanishing point of law, and somehow the people say that it's not a strong law. So it has to be added in the domestic laws, the state laws, the nation laws. So you know that we have discussed about the gender, gender and the state of being male, the female, and the transgender also, and after that the international approach, what the United Nations has adopted, and you know that gender neutrality is a perception that postulates the abolition of discrimination between different sexes in relationship, as well as the implementation of laws. You know that under gender neutral laws, all genders are equal. But I am sharing with you, and law should not discriminate on the basis of the sex. That is the crux of the issue. So the question is this doctrine how much the state has adopted, at which extent the the, the state has just adopted this doctrine that there should not be any discrimination on the basis of sex, because various grounds of the discrimination are there. The sex is another one. And now it has been multiple decades now we are talking about equality, and the world has literally flooded the entire print and electronic media about it. Everybody seems to be talking about equality, how it is essential for a healthy society, and the ways and methods to achieve the same. One of the most, the notable manifestation of inequality worldwide is gender inequality. So the consequent to a very strong feminist movement that began towards the middle of the 20th century, throwing light on the gross inequality and atrocities that women suffer on a day-to-day basis. A need was felt to make amendments in the different laws that women could come on equal footing with men, and the different legislation was started with, or fairly, perhaps fully legitimate for the time, but the dawn of the passing day has put man in such global position that they are victimized by so intended women empowering legislation. Much less has been said about we have become a president state by approving virtually every possible draconian law in the name of curbing crime against women. It's a very hard fact. It's a very hard fact. And this condoning arbitrary arrest of ordinary citizens and imprisoning them in deplorable conditions. So you know that this decade has acknowledged the need of a gender neutral society. And you know that the gender neutrality is an adjective that is suitable for applicable to or common to both male and female genders. So it is not material whether we are discussing about the male or discussing about the female or we are just that some importance is given to the transgender. No, no, it's not the matter. It's not subject matter. We are talking about the gender neutrality. We are talking about gender justice. We should not focus on one particular gender, either it's male or female or transgender. So we invent a kind of society where equality will be established in its true sense, and established not at the cost of any gender. And it's not a very good preposition that you are just favoring one sex on the cost of the other sex. It's not an equilibrium of law. It has to maintain. So you know that when we are discussing different laws, there is section 125 of for example, CRPC, section 125. And 125, the CRPC sets out the concept of maintenance in India. You know it. As well as different individual laws that extend the right to maintenance not only to the wife but also to her parents and children. Maintenance itself is a part of social justice. No problem. And it is considered the fundamental duty of a man to maintain his wife, children, and parents so long as they are not capable of maintaining themselves. So the law of the maintenance was exclusively made with an intent to radiate a major duty on the male to maintain their dependence. And somehow in some personal laws are also considered the gender bias and they compare the duty upon only man to maintain his wife and children. You know that the IPC in its basic form is the main criminal code of India, which gives all the cases and punishment that a person committing a crime is liable. You know that to be charged with and covers an Indian citizen or a person of Indian origin. And Section 2 of the said Act actually find that not otherwise for the act or omission contrary to the provisions thereof, of which we shall be guilty within India. As is established by this section, the law doesn't distinguish between criminals, and every person who has committed or an offense is liable to punishment under. However, however, the assumed mindset that all violence is male generated does not only create gender divide in society, but provides a shield to the crime perpetrated by women. And the women commit crime for the same reason that men do. So the crime has no gender, and neither should our laws, unless through some anti-male provision of the Indian code you can go through. Uh, for example, dowry, death, and cruelty of women, rape, adultery, laws dealing with the modesty of women. For example, Section 304B called dowry death. That typically favor women. The term dowry death sparks vivid imagination once ahead of a woman being haunted and husband and finally hanged to death within the four walls of our house. And feminists have us believe that every unnatural or untimely death of a married woman is dowry. Not only that, the feminists have a role on bride killing and dowry husband. Look, like Indian men have an uncanny propensity to commit violence on their wives for the money and property. So the section 304B, what it says that if the death of a woman is caused by burns or bodily injury or any other abnormal circumstances within 7 years of her marriage, provided she has been subject to cruelty or harassment by her husband or any of his relatives for or in connection with demand for dowry. Such husband or such relative shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. That is the law. So every year, twice as many married men compared to women commit suicide, succumb to verbal, emotional, economic, and physical abuse by their wives and in-laws. The scenario has been changed. I always share this view. It's my personal view. You may agree, may not. That in the coming time, after 20 or 30 years, in our country, the society, I hope so, it will be that the whole scenario will be changed. That's not being changed. Now it's being changed. That after 30 to 40 years, the society will be dominated by male, female, not the male. You can see with how much they are progressing. And definitely it will be a very positive issue for the nation. And in terms of the progress, it is necessary that the almost half majority of, or half population of this country has to be they have the right to the progress. But the The other issue is very different. But the issue is that whether we are when we are just progressing, when we are adopting the constitution, the whole scenario, all the social fabric is being changed. Why not the law? Now, in some cases, there are some physical or the mental abuse you can see on the husband or the male part. Even they are compelled and they are not in a position to handle this problem. So they are just doing um, suicide or trying to do it. So the recent, that's the example. The same, you can just go through the newspaper today or yesterday. You will find that the one person has been just very, tradition was not so strong, so wedlock was not doing its work properly. So the male person, the husband, committed suicide. For example, the Bush cursing is a case of the 2008 controversial case that at least got some media attention. Bush cursing case was got media attention. And sadly, even though his suicide notes years evidence to the fact that he was financially and emotionally destroyed because of false criminal cases filed against him and his family by his wife. If you can remember, you'll find Bush cursing. That is very at the time, in the year of 702, 2008 particularly. And that was the debatable at the time. It was very hot issue at the time. And the people like Pushkar Singh have just committed suicide. So the entire family also, the trauma. Even she was, so the wife was not even called in for questioning by the police until some family rights activists mounted pressure on them. Is it not the law, a biased law? You will not say it's law against one neutral gender. Is it gender neutrality? Death of these person or the man make for the bereaved story in newspaper stating that a certain man killed himself due to family issues for all the financial problems. The same case is Sayyid Makhdoom case, but similar. And the Supreme Court in the case of Sushil Kumar Sharma Vasim of India observed that such provisions are intended to be used as a shield and not an assassin's weapon. The Supreme Court is bound to say. And the court and the legislature have to make certain changes if the laws of the matrimonial society are to be of any deterrence. Come, you see, the look at Section 498, capital A, cruelty against women. But Section 49A specifies that if cruelty and harassment are shown to be reflected upon a married woman by a husband or by any relative or husband, such husband or such relatives of the husband shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. This section should be read along with Section 113A of the Indian Evidence Act to raise the presumption regarding abetment of suicide by the husband of a married woman. Read the Section 113A with Section 419A. 419A. So these two sections are non-bailable, non-compoundable, and cognizable offenses in India. The clear intention behind these provisions is to fasten guilt on the husband or in-laws, though they might not, in fact, have caused the death of one child. And it has become custom to claim that all the women have been driving to suicide, and due to that, it has. And under this section, you know that even if the allegation is false, there will be a trial, and husband is considered guilty until proven innocent. You know that our FS code has termed this misuse the law as a legal terrorism. Justice Saldana's view that are a testimony to the way these laws are being misused to the detriment of innocent citizens. So we need to sound a note of caution that the police and investigating authorities should not improperly and technically jump to the conclusion that merely because death has occurred, that ipso facto criminal offense has been committed. In as many as 44% almost of these cases, prosecution thoroughly unjustified. And the consequences of these charges are extremely grave because the accused husband and the invariably family members are placed under the arrest. There are serious social and economic repercussions. Serious social and economic repercussions of section like 498A of IPC. Another section and another provision of the penal code just talks about the you can say the special privilege or affirmative action talked about. But now it is also there are some questions, there are some queries you can ask, and you can discuss here. To rape, you must be male, and to be raped, you must be a woman, according to Section 75 of the IPC. Men are not recognized as rape victims. That's the problem. Section 377 of India's anti-sodomy law is the only choice for male victims of sexual offense. Section 377 can give a benefit of this law, not under Section 303. So the rule, on the other hand, is riddled with difficulties. And if a male survivor is attacked by a male abuser, the abuse is not considered rape. There is no distinction between consensual and non-consensual acts between male adults in the law. Furthermore, if the attacker is a woman, the victim is left with no recourse. That is the issue. That is the issue. And it is worth noting that the rape and sexual assault offenses were gender neutral, and in the criminal law, I mean, but ordinance of 2013, that the word rape was fully replaced with the term sexual harassment. However, after considerable opposition from unions in the organization, that was amended to make the crimes of rape and sexual assault gender specific. Gender specific. Feminists have made different arguments in favor of this stance, and such as man not being as weak as women, man still having sex, women's inability to rape man, and not being equally affected by rape, and so on, so on. So, in a report, you can find it was discovered that 16.1% of the 222 Indian man pulled and had been tricked and having sex. So, despite the fact that male rape is not as well as studied as female rape, and there are many reports that indicate men are raped, and that the incidence of male rape is higher than commonly assumed. And example, you can support that for the past 3 years, this 16-year-old probably his best friend's mother had been sexually assaulted. It's a case of the 2015. That the mother of friends, best friend's mother, the boy was only 16 years old, and his best friend's mother had been having sexually assaulting him. Male rape occurs but it is seldom reported. Countries with gender neutral rape laws without doubt have the lowest rape rates in the world. So that is the problem with the another provision of the Indian code or the statute. It deals with assault. This is section 354. Come to section 354. And 354, I think, deals with the assault with intent to outrage the modesty of a woman. However, there is no such law to protect the modesty of a woman. That is the problem. And divorce and child custody laws are biased against men because it allows every wife to stop men from seeing their children for a long time. In India, child custody is only given to the father if the mother is mentally ill or has abandoned the child at home. At the moment, two laws govern child custody in divorce cases: the Guardians and Wars Act of 1990 and the Hindu Minority and the Guardianship Act 1996. However, neither statute includes option for shared parenting or joint custody. So we should think over it. Application may be there, but somehow some gender inequality may be removed. We cannot remove the inequalities 100%, but we can remove the gender inequality more than the majority. Okay. So we will consider as a very successful state if we can remove the contradictions, we can remove the difficulty to improve or to improve the condition for all, either a male or female or transgender. So if a kid, for example, if a kid is born during a marriage or within 20 days of divorce, the child is considered legitimate. And in that, the child support and inheritance under the Evidence Act of 1872. Uh, I think, okay. We have discussed here about the gender neutral law and the international instrumentalities and the courts have somehow. And the courts may nonetheless decide to disregard genetic evidence and order a non-biological parent to pay child support. The Child's Rights Initiative for Shared Parenting, this called KIRS, has lobbied for fair child access legislation, claiming that current custody laws are gender-based and has asked for changes to the Guardians and Wars Act to make joint parenting a requirement. Why must be one person, either the father or mother, should be declared as a parent? Why not the joint parenting? Why not? That's the question. So it has asked the changes, particularly Guardian Nevada Act. And in this regard, the Karnataka High Court granted both parents equal study of a 12 years old child on September 12, 2013. The case at the time was very famous. And the boy must live with his mother from July 1 to December 31 each year, and his father from January 1 to June 30 each year. It's called joint parenting. Until he reaches the age of adulthood, as per the decision of the Karnataka High Court. Both parents are granted visitation rights on Saturday and Sunday. Then the child was not in school. When the child was in the custody of one parent, he or she was also allowed to call or video chat with the other parent. The court also ruled that the child's education and other expenses be shared equally by both parents. And in the in the year of 2015, the Mumbai Bandra Family Court became the first in India to require both the mother petitioner and the father respondent. to establish a parenting plan and then to establish shared parenting plan based on the plan filed by both of them. And prior to Karnataka High Court judgment, this something similar, but was not based on the definition of shared parenting plan. So, you know that it did not mention it at all. The decision sets a new precedent by prioritizing the best interests of the kid rather than making a show of it by awarding custody to moms and relegating fathers to the role of sole support provider. Now, come to the another issue of gender neutrality law. Everybody of the uh, legal field knows about the decision of the Vishaka. It's a historic case, and Vishaka was the state of Rajasthan, which was promulgated into the Sexual Harassment of Women at Workplace, the Prevention, Prohibition, and Redressal Act 2013, was the first codified legislation to deal with sexual harassment of women at work. The Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013 is not gender neutral and applies to the protection of women only. The bill was originally gender neutral according to Rajesh Khair, the member of the SIFF, until the Ministry of Women and Child Development, Sustain and Youth interfered and altered the name. He said that it was an outdated concept to consider that the only women suffer from sexual harassment. So it is condemned as a type of violation of the fundamental right to gender equality and the right to life and liberty, infringing under Article 40, 50, 19, and 21 of the Indian Constitution. And there's an incident in 2020, I think it's month of February. The Supreme Court reaffirmed disposition in Punjab and Sindh Bank about the Durgesh Kaur. The fundamental difficulty with sexual harassment regulations that they are not gender neutral. There is only an aggrieved women can submit a sexual harassment complaint in the current state of affairs. Men and transgender people are not allowed to bring a sexual harassment complaint at work under the law. No one believes or listen. No one believes or listen when a man tries to convey his emotions or explain his issues, harassing encounters or hardships. Instead, they lock it off. Some males are even embarrassed to discuss it. Everyone in India says that the women are the only ones who are victims. But in some cases, the situation is very different. It's very different. Those constant examples of harassment against men, on the other hand, go ignored. Thousands of surveys and statistics on crime against women are available on the internet. You can find. It's very easy to access. And you know that there is no doubt that women are subjected to more harassment than men. However, there are a number of male victims who must be adequately addressed because we are living in such a country where the constitution is supreme, but the constitution will say equality. It talks about equality. The special provision can be made, but doesn't mean the special provision doesn't mean the bias against towards all or biasness towards one people or the one section of people or one community or one section of society. So it has to be maintained strictly. It has to be clear. We are not implying that every woman does it. Rather, India has a considerable number of such examples. However, the human rights must be equitable for everyone, regardless of gender, color, or socioeconomic status. So the likewise law must be equal for all people, regardless of gender. And criminal crimes of any form of harassment must be handled with as soon as possible, and harsh measure must be applied. According to this survey uh, performed by St. Xavier School, that 66% of respondents felt that women abuse the laws designed to protect them in order to exact revenge or harass males. That is survey and performed by very reputed institution, St. Xavier School, also called 66%, more than 50%, means the majority of people of the respondent felt that women abuse the laws designed to protect them in order to get revenge or to settle down the score. So the goal of this survey was, it was done among 2,000 persons in Mumbai, was to address the fact that the men are also subjected to harassment and discrimination. According to a poll conducted by Economic Times and Sinopet, almost 38% of the males asked in seven major Indian cities acknowledged to having experienced workplace harassment in some manner. Overall, the sexual harassment of women at workplace prevention and the prohibition and reduce the lack of safety is a comprehensive piece of law aimed at ensuring women's safety, no problem. At work, however, in terms of gender neutrality, that leave the gap. With the approval of the Act such as the Transgender Person Protection Right Act 2019, the more important than ever for the Indian legislation to establish sexual harassment law, all encompassing, gender neutral, and progressive in the 21st century. Though the Justice Verma committee I have just shared with you, chaired by Justice V.S. Verma, and he was the former Chief Justice of the Supreme Court, Justice Lila said this was first woman judge of Delhi High Court who was went on to become Chief Justice of Madhya Pradesh High Court, and said Senior Advocate Gopal Subramaniam, who served as Solicitor General of India, suggested that more legislation for gender neutral laws after the Nirgaya Bill was one of passed by the. That were discussed thoroughly, not passed by the discussion. And now I want to come to the another issue, that the domestic violence laws. And the Domestic Violence Act provides protection to wives and female live-in partner, live-in partner also. That's another kind of the relation. Comparatively, it's a very new phenomenon in India, particularly live-in relationship. But when the people, when the citizen of this country, when the individual is being protected, why not the live-in relationship? That's the approach of the state. Men like women are victims of gender-based violence in India. Because most women are victims of violence, there is a widespread misconception that domestic violence is gender specific. It's incorrect. In a patriarchal or male dominant society like India, it can be difficult to comprehend that even man can be victim of some domestic violence. Domestic violence against man has become more common in recent years, and this gender-based violence affects almost 52 or you can say more than 50% of married men in India. There is a survey conducted by rural communities of Haryana with 1,000 married men ranging in age from 21 to 49, so rural in rural communities. In their lifetime, more than 50% of the men have been subjected to some form of torture, or violence by their spouses or intimate partners. In the recent years, that more than 10% of men have been subjected to gender-based violence by their spouses or intimate partners. That's an alarming issue. Emotional abuse is the most common form of spousal or domestic violence against men, with physical abuse coming in second. That's that is the problem. And you know that many cases go undetected, and since many are either ashamed to disclose abuse or afraid of false allegation in the race, particularly in society, especially with the men, they are not speaking or they are not saying their problem or they are harassed either due to the social fabric or the age-old conception that the male has to dominate over the female. So the men frequently feel discriminated against or nervous about speaking up about the violence they witness because they are afraid of being judged and labeled as wimpy and effeminate. They believe their fight against violence has been vain due to the Indian either different provision of the Indian laws or gender-specific rules and clauses. They believe they have failed in their protective position. Many frequently believe that disclosing the violence will cause undue inconvenience and they don't want to face legal consequences. That is the issue, you know that. The Indian Social Awareness and Activism Forum, that's called INSAF, has produced a bill to protect man and boys from domestic abuse perpetrated by their spouses, girlfriends, and parents, saving men from intimatal act. Is is the name of the proposal that which was given, which the organization hoped to propose in Parliament for consideration. The Protection of Women from Domestic Violence Act 2005 was uh, or GBX in short, PWDBA, that's called 2005 Act. It's very clear on one point. It is only for the protection of the women, particularly speaking only wives in the household. The name of the act itself makes it very clear. In 2017, the High Court of the Karnataka issued an opinion that appears to redefine the entire DV Act by recommending that complaint made by a husband against his wife and in-laws be examined. It also refers to a Supreme Court decision that Harsora was a Harsora that modified the definition of respondent under the DV Act to include both male and female respondents. And you know that uh, a huge number of uh, religious people or like hermits, sadhus, have left their marriages to become holy man or yogis in Madhya Pradesh, Jabal, Amarkantak. And at the time, the news came that at Amarkantak and the Hoshangabad region, various means have been converted to learn as life or as like we are there, like hermit or sadhu. So what was the reason? Some people say, the journalists say, some newspaper people say that because they were very depressed with the marriage, with their marriage. So they declared themselves as yogi or Baba or Sadhu. So that is the problem, it's the crux of the problem. Why we have to do discrimination on the basis of fact? Suppose a person is male, why it has to be discriminated? Why not the doctrine of equality has to be followed equally? So the domestic abuse against man has risen dramatically in India, and as a result of the COVID-19 lockdown in April 2020, uh, more about 2,000 men from 22 Indian states contacted the same Indian family, that was the organization, citing domestic assault by their spouse. See, the cases coming from the male side. They are saying that they are being harassed in COVID-19. And on other points, or on other hand, you can find the female also saying in some cases that not they are being harassed by the man. So you know that as a student of jurisprudence, as a student of this constitutional law, that we should think about it. But the effect of the law is there because during the shutdown or lockdown, multiple incidents of the room burning have also been recorded in various districts of India, and some harassment is also there. Now, my viewers, you know that there's another section called LGBT people, and this violence and the violation are a part of the daily life for an LGBTQ plus person. While the legal system is usually used against these communities, the law need to laws considering the fluidity of a gender and how wide variety of person may exist who don't conform to set gender structures. I think that these people, LGBTQ, have to be just taken into consideration when we are talking about the equality. And you know that my reviews, the gender neutral rights are not only important to prevent equality in society, but also it gives all human beings a sense of security. Gender neutrality, when practiced in its true sense, helps to create a balance in the society and demolishes the sense of superiority that generally gives rise to crimes. Women's privileges, no doubt, but needs to be modified and ensure that men are protected too. We are not against the female class. We are not against the women. We are not against the one particular community, section of society. But there must be a equilibrium. I think the landmark judgment of the Joseph Shine was of India, the apex court, that decriminalized adultery, striking down Section 497 of the Independent Code. You know it very well about it. Is stating that husband is not the master of his wife. See what the Supreme Court is saying, that the husband is not the master of his wife, and women should not be considered as the property of their husband or father anymore. The female is not the property of the husband. She is an independent entity. She is she is the same like the man. So what the code is saying, and it is a time to just think about it. Uh, every mindset has to be changed that a female is not the property of the male. So they have equal status in the society and should be given every opportunity to put their stance forward. This is really appreciable judgmentally, and the same steps should be taken when rights of the man are being encroached in the center of laws to maintain a balanced society. That's what I'm sharing with you. The need of the hour is a system where women are protected and men are not harassed with false charges. It is a tightrope that the country is walking on where the crime against women is high and the crime committed by women is also on the rise. That is the problem. So what the Russell Pond says about it, there must be equilibrium. There must be some vested interest may clash with each other. It's the duty of the lawmakers to maintain the balance between vested interest. So a balance has to be reached to ensure that equality is not jostled and reaches its accurate definition by merging with humanism. Because equality is at the heart of feminism, we should all agree that gender neutrality is the first step towards achieving it, and the result establishing Article 14 of the Indian Constitution in its true sense, not mere words. As the result, gender inequality has little to do with feminism, somehow the people say, and rather it aims to achieve the feminist goal of equality. It requires equally enjoyment by both women and men of social valued goods, all the opportunities and the resources and rewards. And I'm very thankful to all of you, particularly the organizer of this FDP, and definitely a result for the association. A very young team is there, and I hope we make a difference. And my
Thank you, sir.
wishes and all I wish.
It's a very
Thank you all.
informative session, sir. Thank you. Now the time for formal vote of thanks, sir. I, Dr. Sadaf Khan, on behalf of the entire Faculty of Law, Integral University, would like to express my pleasure to deliver vote of thanks for today's session. With profound privilege, I would like to record my sincere appreciation to Dr. Muhammad Tariq, sir, Professor, Faculty of Law, Aligarh Muslim University, Aligarh, for giving us time for his busiest schedule and discuss with us the topic related to gender neutral laws need to amend old age panel code in India. Sir has preciously explained the topic in relevance or connection to sustainable development goals set by United Nations. I hope that everyone present here will have a lot to take away from your inspiring and thought-provoking words. Lastly, I also want to thank all the participants from multidisciplinary field for joining us virtually and participating actively in the session. Thank you all. To conclude, let me once again reiterate my gratitude to you, sir. Thank you, sir, for virtual addressing us. Thank you, sir.
Thanks a lot.
Thank you.
May I leave?
Yes, sir. Yes, sir.
Thank you very much. And again, congratulations to a very young team of the Department of Law, the Faculty of Law, Integral University. Inshallah, you will make a difference. My wishes are
Inshallah,
with
sir.
you.
Inshallah, sir.
Okay.
Thank you, sir.
Thank you.
Thank you once again, sir.